Thank you, Neale, and thank you, Real Estate Investor, for this opportunity to be part of this. I hope that my insights that I've gained out of practicing law, being a managing agent, and also the CEO of Stratafin, and where we are constantly busy with collections, will be able to assist your managing agents and also some of the trustees that are on the panel here today. So I have identified 3 aspects as what is required for rock-solid levy collections. And those 3 aspects, I just want to make sure that I've got the screen. There you go. That we've got it on the screen. So the 3 aspects that is important for rock-solid collections is to ensure that you've got a rock-solid process in raising your levies, a rock-solid internal collections process, and then a rock-solid external collection process. So at Stratafin, we understand this process, and we make sure then when we get involved that we do a proper due diligence and make 100% certain that this process has been followed. So in respect of the raising of levies, Section 3 of the Sectional Title Management Act places an obligation on the scheme to raise levies. And then Section 3(2) makes those levies payable from the date that the trustees sign a resolution to the effect that the levies that were approved in a budget was adopted by the scheme and can be raised. So the court then in general, and this we have seen throughout many matters that are in court, and many queries raised throughout the time period that we've been running it. The court requires a certain amount of things and questions that they ask to make sure that the levies were raised correctly. So they will want to see the budget. They want to see that there was a budget in place that was drawn up by the trustees, in all probability with the help of the managing agent and portfolio managers. And again, now they're also required to understand finances. So the poor managing agents. When you draw up this budget, then obviously you need to take into consideration cash flow. So whatever is raised as levies is not necessarily going to come in during that course of year. So you need to make sure that cash flow is foremost in your mind, and levies need to be raised in such a way that there will be sufficient levies even if there is a default. Otherwise, the scheme will run into problems and obviously will not be able to pay for the services and the upkeep and maintenance. Also, you need to make sure that there is sufficient money that if write-offs are required, that should be done. Now, write-offs is a contentious issue, but unfortunately, I think that we are all aware that IFRS or IFRS for SMEs are applicable and in accordance with IFRS 9, therefore it is a requirement. So we need to make sure in our budgets that there is a provision that is made for write-offs, which obviously will have an effect on the increase of levies. Provisions need to be made, again, provisions for write-offs and other provisions where money should be required and so forth. So all those things need to be in there. Something that we in practice see that not a lot is being done about that is that bodies corporates do not necessarily raise money for legal fees. And I think the reason for that is historic, because in terms of the old act, all legal fees were apportioned, all fees and expenses were apportioned to the owner that were in arrears, and where legal action had to be taken against that person. So in terms of the new act, that is not a requirement, or the act specifically states that only those tax legal fees or the agreed legal fees can be apportioned to that owner. So therefore, it's important that Bodies Corporate does make provision for legal fees so that there is money in the budget to pay for those fees whilst the legal process is continuing. There needs to be a proper AGM called. I've also put in here SGM because we have also seen many schemes that call SGMs prior to an AGM, where they then would raise levies, and that's the only function of that AGM or SGM, is to raise the levy prior to an AGM so that the scheme does not have a shortfall. Obviously, the Act also makes provision for that in the sense that trustees are entitled to raise the levies until the next financial year up to a maximum of 10%. So when courts look at levies, they would then require that there was a budget, that an AGM was called, or that the trustees have raised it in accordance with the authority. That proper notice of the AGM was given by registered post or delivery to the owners. Obviously, email is an additional delivery method, although we want to make that a delivery method of choice. That is not what the Act requires. That there was a quorum at that AGM, and obviously all the issues regarding a proxy or proxies at that AGM to ensure that there is a quorum, and that budget was then approved with or without changes by the owners. Trustees needs to be elected, and those trustees then need to have a first meeting of trustees where they then resolve to implement the AGM resolution in respect of levies. So in terms of section 3.2, the levies are then, from that moment, the levies accrue. So I've also put in there Management Rule 25. Management Rule 25 requires the sending out of a letter to confirm the levies that were raised, and also your letters of demand. But in the matter of Kleber and Okabeng, the court found that those are administrative issues and does not invalidate the raising of levies if those were not followed. So you can still recover your levies if you have followed those processes. In respect of the trustees' resolution to implement the AGM resolution, they need to determine a date from which this levies will become due and payable, the manner in which is payable. So is it a monthly, quarterly, yearly? And then obviously the rules also make provision that a discount can be applied where all these levies are paid in advance. So these are the factors that the courts look at when they decide to grant a default judgment or not. So when a matter is referred to court and you do not get judgments, and the attorneys come back to you and say, we are waiting, we have received queries, these are the queries that they need to deal with, and these are the compliance documents that you need to give to the attorneys to enable them to actually successfully recover those levies through a court of law. So you also need to have a rock solid internal process, and that solid internal process obviously stems from a trustee's resolution to implement the AGM decision. So as I explained, the trustees must make that decision to charge the levies or to raise the levies, and those levies should then be apportioned in terms of the PQ or other way in another way that was determined at the setup of that scheme. It also should determine when these levies are payable, because obviously if we don't have a date, then we have all this discrepancies and confusion. Is it payable on the 1st of the month, on the 7th of the month, and so forth? There is a general perception going around that something that's payable on the 1st needs only to be payable on the 7th. That is just something that happened as practice in the rental industry, and it has almost now become a norm. It is not a norm at all in the law. If something is payable by a certain date, the person is in mora or in breach at the moment that he does not pay. So therefore, if levies is payable by the 1st of the month, that is the date that levies are payable, and interest becomes applicable from that moment. We will discuss interest a bit further on, but that is the date of mora. Obviously, the trustees' decision how to implement is subject to owners' directions and restrictions. Owners will, however, not be able to put a restriction on trustees to collect. So we are involved in many inner city schemes, and these schemes almost become hijacked. And normally they get hijacked by the people that are in arrears and are not paying levies, and they would then get themselves into positions of trustees if judgments have not been granted against them, and they would then hinder the process of collection. So the obligation on a scheme is to levy and to collect those levies, and that is also a primary objective of trustees, to make sure that there are levies and that those levies are collected. So owners will not be able to restrict the trustees from actually recovering the levies. There could be, however, different other directions that are given to owners. So owners will be able to say that interest should be charged only from that date, 30 days in arrears, or it should only be charged 7 days in arrears. Interest must be limited to X amount, and so forth. So one needs to have cognizance of the owner's directions and restrictions as well when you're busy with your internal process. Then the trustees need to have a interest resolution that needs to be taken on a yearly basis. This is the trustees' prerogative to charge interest. Obviously, the owners can step into the arena here and make that one of the directions or restrictions that they do give. But in general, one would think that that is a prerogative of the trustees. What we have seen is happening in some schemes is that there will be staggered interest rates. So interest rates would be charged when the person is in arrears for the first 14 days at a much lower rate, and then after 14 days slightly higher to 30 days, and then the maximum interest rate after, say, 30 days or 60 days. The norm that we currently see in the industry is about 2% per month, compounded monthly in arrears. It's slightly more than 24% because it's compounded. And that is the rate of incidental credit. The Sectional Title Schemes Management Act and the prescribed management rules says that an interest rate that does not exceed the interest rate as determined by the National Credit Act can be charged. The rules are actually silent on which part of the Credit Act. There are various parts of the Credit Act. There's normal credit, there's payday loans, there are incidental credit, and so forth. But CSOS has decided that that rate is the incidental credit rate. Levies does not become an incidental credit when it's not paid. There's case law to that effect. But that in any event is the norm that is currently applied in the industry as the norm of the maximum interest rate. I do understand that when you have a staggered interest rate, it makes the work for the managing agents even more, because now I would think that the systems like WeConnect and so forth would apply a single interest rate to all arrears. Where if you have a staggered interest rate, it will mean that people will have to actually manually do that. And I know that managing agents are overworked already, so that will just place an additional burden on them. But that is a way that one can make sure that people that fall behind this 1 or 2 days and then make their payment because their salary only reflects on a certain day, that they are not burdened with an exorbitant interest rate like 2% per month, and just pays a slight interest rate. What we also find is that accounts are debited with amounts that were not properly authorized. So penalties are being put onto the accounts, admin fees, SMS, letters, amounts for those, attorney's fees prior to taxation, and attorney's fees that are on an attorney and own client scale. So all of these debits, once the court is required to grant a judgment, they will ask for the ledger account of that debtor, and they will actually go through each and every entry on that ledger. And if one cannot prove that your rules allow for a penalty, then the court will raise that as an objection and won't grant judgment, and so forth in respect of admin fees, SMSs, letters, and so forth. If the managing agent is registered as a debt collector and has a mandate to collect from the body corporate, then obviously the court will allow it, but the court will then also want to see that mandate to see that they were entitled to charge those fees and that they were appointed by the scheme to actually do these collections. I think it's also important for schemes and managing agents to assist schemes to implement a credit policy in the scheme. So this must be drawn up by the trustees in conjunction with the managing agent, and obviously it will be scheme specific. So every scheme will have their own credit policy that works for them and would then implement that. One can have a grace period, for example, of 7 days, if that is the requirement, a first demand after 14 days, a formal demand after 21 days, and then after 30 days, one would do action, be it CISOS action, court action, or your internal action that you want to take. So it is important that one drafts a credit policy, and that policy may be made available to owners, that they understand how this process is going to be followed, and what the trustees will do to make sure that the amounts are collected. Some practical solutions that, from my experience when I was managing schemes, and specifically also if one takes into consideration that schemes must have an internal dispute process, it's important to have that internal process to invite defaulters to a trustees meeting. I would avoid one-on-ones in general, so bring in a defaulter into a trustees meeting where there is a trustees meeting that deals with arrears. Explain to owners the importance of levies, and that is the lifeblood of the scheme, and that no scheme can actually run unless they have sufficient money and sufficient cash flow to pay for these expenses. Explain the importance of cash flow as well, because it doesn't mean that you are going to pay your levies and you're only going to pay it in 3 months' time, that the scheme will have sufficient cash flow to pay for the security, to pay for the services rendered by the council. Require a verbal undertaking at that meeting when payment will take place. I've also said that in many occasions on webinars, that it's always better to have an agreement with an owner that he will pay and rather get payment on a monthly basis than go through the legal process. The legal process is long and tedious and requires expertise to manage, and it's much easier to get money where people pay it off than to go through a process where you have to go through CSOS or through the courts to try and recover that money. Confirm that verbal undertaking by sending a letter, or alternatively have an acknowledgement of debt drawn up where the debtor has repeatedly not complied with these verbal undertakings. The signing of an acknowledgement of debt makes the collection process easier. One would not then have to go through the process of proving all the elements that I've explained earlier on, the budget, the AGM, the approval, the trustees resolution, and so forth. So you don't have to go through that to then get a default judgment against that debtor. You can sue on the acknowledgement of debt, and it's far more difficult for a defendant under those circumstances to then raise a defense and make the matter an opposed matter rather than an unopposed matter. So I will speak a bit later on between the difference of the two and the time periods involved in that respect. So get your debtors to sign acknowledgement of debt, and then if there's no payment in accordance with that, then issue summons on the acknowledgement of debt. What I also found was something that helped tremendously in schemes was to allocate trustees per portion of a scheme. Once the internal process was held, there was a meeting with these owners that specific trustee that then deals with that specific portion of the scheme goes and have a chat to that owner and say, but you made an undertaking to make payment. It is not forthcoming. What is the problem? How can we assist? How can we get payment? And then again, it gives an opportunity to have an acknowledgement of debt signs, which makes the process much easier. Also discuss staggered interest rates. That obviously is also once a debtor realizes that the interest is in a staggered way and he's going to pay far more interest, then they are far more likely to make payment in respect of those debts. What the trustees must also do is once they have drafted a credit policy, that credit policy must be taken up in a trustees resolution. So a vote must be taken to implement that trustees resolution. And it is also important to implement that resolution on the basis that the managing agent is given authority to apply the terms of this credit policy, which makes it then unnecessary for the trustees to get a resolution on a monthly basis from the trustees to say, you can now send out a letter of demand to person A, or you can proceed with a summons. If the whole process is built into the policy, then you don't have delays and you can proceed with your collection process in a much more structured way, and also report back to your client regarding the collection of those monies outstanding. I also just want to have a chat about handling of legal fees. I said earlier on, amounts can't be debited to the accounts and courts won't grant judgments where these amounts were debited to the accounts without the necessary authorization or permission per the rules. One would have to open a legal expense account in the body corporate's books, and the legal expense account should be debited with all these legal expenses coming from the attorneys if that is the route that you choose to follow. So the owner's account is not debited with that. And then that legal expense is paid from the general administrative budget. And you can only do so if you have budgeted for that, like I explained earlier on in my discussion. So therefore, it's important that you do have legal fees that you budget for, you debit the legal expense account, and payment is made to the attorney in that respect. Only once judgment was obtained and your bill of cost was taxed or was agreed upon by the debtor, only at that stage can you then credit the legal expense account, the general legal expense account, and debit the owner's account with that legal fee that was then taxed or that was agreed. In general, one would also have a clause in your acknowledgement of debt that says that the owner agrees to all legal fees on an attorney and own client scale. So it also makes it far easier then to allocate all the legal fees to that owner and not only the taxed or agreed fees. So that is the correct way of dealing with it. And that is the way that the courts look at it when they grant judgment. Okay, so now if we have to deal with the rock solid external process, we have choices that need to be made. Obviously, the first choice that we can make is to go through CSOS. I hear a lot that it is being said that CSOS is for free. I marked it boldly. CSOS is not for free. Every person is paying a levy to them on a monthly basis. And I think over the time period that people stay in a scheme, they will pay far more than what would have been paid by a defaulting owner in respect of the legal fees. But be that as it may, that's just my opinion and my personal opinion in that regard. At Stratafin, we do not use CSOS in respect of the collection of levies. We believe that the inherent risks in doing so is far too great. And as such, we approach the courts in that respect. The inherent risks that to us are problems is that there is no appeal on the fact. So if a adjudicator makes an incorrect factual decision, then that can't be appealed. I'm saying there's no certainty of outcome. We have seen matters where the facts look clear as glass and the outcome was not correct. So we believe that there is still a problem in respect of adjudications. No legal representation is allowed. I think that is part of the problem, is that the adjudicators can't be shown what the legal position is always. Currently, those applications are going to CSOS on paper only, so they don't do in-person adjudications, which obviously also makes it more difficult to get all the facts in front of the adjudicator, and then also the time period for an order to be granted. And then once that order is granted and there is non-compliance, then in any event, you have to go the court process to make that adjudication an order of court. And then the collection process in any event follows the court process and has to go through the specific court. The largest portion of a legal collection sits in the sale and execution process. So about 60% of all the costs spent in respect of a collection matter sits in that last portion. So the amount of money that is saved to get a default judgment from CSOS or the equivalent of a default judgment of CSOS is not worth, in my mind, the risks. Then the other huge problem that we have with CISOs is prescription. They do not apply Section 3 or Section 13 of the Prescription Act. So they are of the opinion that levy debts prescribe. There is case law that says it does not. Section 3 and Section 13, I would think, is fairly open, and anybody can understand it, that as long as you are a member of a governing body, its prescription is suspended. So therefore, all owners, in respect of all owners of schemes, prescription is suspended. The other problem is that Section 17 of the Prescription Act says that no court can apply mero moto prescription. CISOs does, in contravention with that. Okay, I see I'm running out of time, so I will have to go slightly fast, I would think. Obviously, if you go through the court process, you need to pick a specialist attorney, make sure that you get horses for courses, make sure that you get somebody that understands sectional title and sectional title collections. Agree on the fee structure. There are attorney and client fees, which is normally our highest scale of fees that is charged by attorneys to their clients. And then there's the party and party fee, which is a lower scale, which is the fee that is recoverable from the debtor. Make sure that you get your attorney and client fee and party fee as close together as possible, because obviously what you can't recover from a party and party scale from the debtor, you as the scheme will have to pay over to the attorney, and it comes out of the administrative budget. Again, in the Kleber versus Okabeng matter, the court does say that there is possibility of charging an owner a higher fee, but the facts of the matter will be relevant in those cases. You need to choose a court. It's always the plaintiff, so the body corporate, or represented by the managing agent, that will decide where this will go: magistrates court, regional court, or high court. We have found over the years that collections through the magistrates court and the regional courts get to a certain stage prior to sales and execution, and from there they do not move any further or slightly. We move all our matters through the High Court, so there is a higher cost involved in that respect. So the body corporate can then be penalized by a court only granting a party and party fee on the magistrates court scale, but the efficiency is far better, and it's much easier to collect through that. The summons process to go through the issuing of summons, an undefended matter takes anything from 18 to 24 months. Defended matters, where somebody raises a defense, from 24 to 60 months. There are alternatives that can happen by application, so an attachment of a rental, or that can also take through CISOS, attachment of a person's salary, and a application to disconnect services. These are all applications that will have to be brought by the body corporate. I just also then gave the warning, never take the law into your own hands. That creates a situation of spoliation, and where trustees can be held personally liable as a result of gross negligence. Cost of a legal action can be anything from
Neale, yeah.
Yes.
Just 2 minutes. We are running a little bit over time. I know
Perfect.
you've got a lot of questions, a lot of interest,
Perfect.
but 2 minutes if you don't mind.
Perfect. I'm almost finished. Legal cost. On an opposed scale, on an unopposed scale in the High Court, varies from 60 to about 120,000 Rand. On a tax scale, anything from 25 to 35,000 Rand. So the owners will be liable for the difference between that. Then I think the last thing that I wanted to deal with was sales in execution. When a property is sold in execution, so once you have judgment and you've attached movables, then you move to sale in execution. You need to get the right to do so. The court takes various factors into consideration: the Constitution, Section 26, the right to housing and dignity. They will have a look if it's a primary residence. They will look at the age of the occupier, children, if the people are indigent people, the size of the debt, and then obviously if there's a bond over the property, and then also the financial well-being of the scheme. So those are the factors that the courts will take into consideration in execution. Even if there is a bond over the property, one can move forward and sell that property in execution, and you will then just require the process to be followed in terms of Rule 46. So I think that is more or less what I wanted to say in respect of collections.